pretrial officer concerning the positive drug screens. Mr. McNair, you understand you are not permitted to take any illegal drugs while this case is pending. One moment, allow me to swear you in. Please raise your right hand. Do you swear or do you affirm the testimony you're going to give this morning will be the truth? You can lower your hand. Go ahead, Mr. McNair.
I had got some people and
all right, good morning. Good morning, good morning. It's Friday morning, August 30th, and we are here to watch several motions that are going to go before Judge Everett, Judge Stephen Everett in Tallahassee there on, good morning, Lou, good morning, Kim, on Donna Adelson's motion, pretrial motions, several that were submitted in the past 2 weeks. So it looks like Judge Everett is dealing with another case right now. So we haven't gotten into anything Adelson related just yet. So we'll just hang out here for a moment. All right. Settle on in. Settle on in. Actually, I'm going to go run and get my coffee really quickly. Don't go anywhere.
At the time this positive screen occurred. Mr. Lamb, do you understand your conditions of release? Let me swear you in. Do you swear or affirm the testimony you're about to give will be the truth?
yes, sir.
You can lower your hand. What is it that you wish to tell me concerning those?
Judge, I'll represent that. I've spoken with Mr. Lamb, and
I guess I was muted.
he believes that he was given a cigarette that was probably laced with something. Did not realize that, and I've made it very clear that he's smoking cigarettes. It's only to be something that he purchases from a store that he sees come out of the box himself. He has had negative tests since, and he's been doing fine since.
Mr. Lamb, as it relates to this condition, I'm going to reiterate the same as I did for Mr. McNair. Your drug screens and not consuming illegal drugs are a material condition of your release. You are not to consume any illegal drugs. If you have a medical condition or an issue that requires you to take narcotics, you may do so if they are prescribed. Do you have any questions about this? From here, Mr. Lamb, same warning that I'm giving to Mr. McNair. If there are any more positive tests or any more issues from here, I am going to strongly consider that to be a material violation of your conditions of release, and you will be taken into custody. Do you understand what I'm saying?
Yes, sir.
Ms. Fernandez, do you have adequate contact with Mr. Lamb?
Yes, I do, Your Honor. Even this morning, I let him know of the room change, and he was here waiting for me.
Mr. Lamb, from here, when is the next case management or date scheduled in this case? Very well. Mr. Lamb, your counsel may waive your appearance. However, you do need to stay in contact with them so you know exactly what is taking place and all future dates that are to be scheduled. I do not want there to be any future issues with drug testing. Are we clear on this?
Yes, sir.
Have a good day.
Thank you.
Still photography, yes. All right, let's turn to the other matter scheduled for this morning. Case number 2023 CF 3226, State versus Donna Adelson.
Here we go, folks.
All counsel of record may make their appearances.
Georgia Kappelman for the state, Your Honor.
Daniel Rash, on behalf of the state. Alex Morris on behalf of the state.
Oh, before I get off Lamb and McNair, Ms. Dugan, I neglected
Ooh.
to ask you if you have anything
Donna.
to add on behalf of the state.
My word.
Bailiffs, if you please could get back to defense counsel. Do you have anything to add,
Wow.
Ms. Dugan? Very well.
Rash
Continue
shave.
with Ms. Adelson at this time. Want to go through all the motions that we are. Oh, let me turn on the Zoom as well before we get rolling.
Judy. Looking rough. Okay, good. Thank you, Lou. Thanks for letting me know. I'm not surprised that she is there in court with her counsel. I guess they busted her out of jail. Looks like she's put on some weight, huh? She's put on some weight. Her hair is natural. Au naturel. Looking inquisitive, but definitely not as chipper as the last set of motions that she was there for.
Ms. Kappelman, Ms. Dugan, how many individuals were you expecting to join via Zoom this morning?
I was thinking at least 3, Your Honor. Let me see.
Oh, I
Markel
see.
and Shelley Markel.
I see Zoom entries for Ruth Markel, Phil Markel, and I believe some other interested parties or onlookers. All right. Beyond that, I will keep an eye on anyone who is attempting to enter. I do see one now for Shelley Markel as well.
Thank you, Judge.
Hi, guys. Good morning. Good
For
morning.
everyone who will be listening via Zoom this morning,
Morning,
you are
Charlene.
not to interfere
Scaviella.
with the proceeding. However, you may listen to the argument of the attorneys and also the court proceedings as they unfold. Again, please do not interfere in any way with the proceedings.
Yes, Charlene. We are here for
Does
justice
the
for Dan.
defense have anyone that you anticipate joining via Zoom? No, Your Honor. Very well. To go through the motions that we're going to hear today, we're going to address the state's motion in limine, the defendant's motion to use a jury questionnaire,
Good.
defendant's motion to suppress wiretap interceptions, defendant's motion to dismiss the indictment for pre-indictment delay or to exclude evidence, the motion to hold the trial in courtroom 3, and also
Fantastic,
the
you
defendant's
guys.
motion in limine. I believe the defense has also filed an additional motion in limine. Mr. Morris can explain as to that as well.
We're probably going to be here for a while, you guys.
The motion was filed based on the receipt after the deadline, the discovery deadline, if you will, for Corbett's presentation, which is 300 and something odd pages. Mr. Ashbaum, there was some back and forth in terms of when we would get it and that sort of thing. We needed it before Sergeant Corbett's deposition, which was taken with...
Talking to a microphone.
Yes, sir.
Standing order of the day. Everyone who speaks, speak into a microphone.
Thank you.
His deposition, Sergeant
Very
Corbin's
helpful.
deposition was taken in the midst of last week. And so the motion was filed immediately on the heels of that, once we learned the information that was associated with his testimony and presentation.
Very well. As to that motion, I've not had an adequate opportunity to review it. I assume the state needs some time to prepare this as well.
I'm happy for it to be heard whenever it's convenient for the court judge.
This was a motion that was filed yesterday, you guys.
Timeline of meeting the jury selection on the 17th. For now, let's tentatively schedule this for September 6th. Please consult with Lynn as to a particular time and courtroom. If I'm going to need additional time before we get to the 6th, I'll let you all know. Right? Oh, and also, the other motion that we will hear today is the defendant's motion to preclude travel as consciousness of guilt.
Judge,
Buckle up.
The motion that was filed this week by the defense, I did go ahead and put that draft of the presentation. It was flash track for you, 329 page one. I sent one or two things since then, I believe, to the defense, and I guess they'll just let us know if they have an issue with that.
Thank you. One other matter that I wanted to address as well before we get into the argument of the motions. Mrs. Adelson, previously I have addressed with you the fact that you are waiving any conflicts as it would relate to the representation.
Nail her down, Judge. Nail her down.
Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand.
I'm so glad that the judge is doing this.
Do you swear or affirm the testimony you're going to give will be the truth? Lower your hand. Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case or a similar case in this matter?
That he lost.
Do you understand that he has a duty to hold in confidence certain aspects of that representation? Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial? As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way? Have you had an ability to consult with other counsel if you wish to have a conflict-free counsel? And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this? Thank you. You may be seated. And again, so it's clear why I'm doing this, ma'am, at this stage, as we move closer to trial, things are going to occur rapidly, including rulings on the motions that you filed, rulings on the state's motion, how this is going to affect the evidence, and how this will ultimately affect your trials. At any point, if you decide that you are no longer willing to waive this conflict concerning the representation, that is something that I'm going to need to address. Do you understand this? If defense counsel as well becomes aware before the next hearing that the conflict is no longer waived, please bring this to the court's attention.
Yes, Your Honor.
All right. Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay. Mr. Morris, Mr. Rauschbaum, whoever is arguing this on behalf of the state, I'll allow you to proceed at this time.
Judge, may I approach the lectern?
You may.
All right, here we go. They're saying the state took too long.
Grammar.
State took too long to bring charges against Donna, so they shouldn't be allowed to do so now.
So Judge, you've read the paper, so I'm not going to go into too much detail other than what's said. I don't want to repeat myself too much, but just to point out a couple things. Here, there are two components that need to be shown. You need to show prejudice. We need to show a delay, first of all. That's clear. I think that's clear on the facts. The murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial, the first trial, Catherine Magbanua and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine Magbanua, Secreto Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I asked the question is because the motion makes reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of your motion, correct?
I mean, yeah, look, she could have been charged anytime after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, and to be clear, this is not a statute of limitation. There is no statute of limitation.
There is none.
So we agree with that.
Kim, that answers your question.
She could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear in 2024. So the only new evidence since then is her trying to get on the airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016, right? And they certainly had it in 2019. So 9 years is 9 years from, I guess, the murder, right? If you're looking at it in any component, you're looking at what would fit under Florida law, under the 11th Circuit law, certainly a time delay, okay? So when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of their main components of their case are call patterns, and I use the word patterns lightly, because in order to show a pattern, you need a length of time to show a pattern. So when they've got call records, they got call records, I believe, starting in May of 2014 through July of 2014. So they got a very short period of time. Because she wasn't charged in a timely fashion, call records showing that there is no pattern, that this is exactly what would have happened earlier, these pattern of calls existed back then, but they haven't existed for years.
What was the retention policy for the phone service provider?
I believe it was 3.5 to 4 years. So that would take you back to 2019, give or take. And so we're able to not fully defend that point because the records don't exist anymore. That's prejudice. The second component are some text messages. So they have text messages where they claim it shows that she is outside of Charlie Adelson's house. We have to defend that. It's their one main piece of evidence. This is a premeditated crime they're charged with. Is there one piece of evidence after the murder? There's very little piece of evidence after the murder other than that and the wires. So the way to defend that is through SunPass records. Those SunPass records don't exist anymore. Now,
What is the record retention on the Sun bill?
3.5 years is what we're told. And that's what Agent Corbett testified to at the last trial. So, Judge, it's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves. Now, the second component is a bad faith component. I think the prejudice component is clearly established here. The bad faith component, it's important to know that under bad faith, you do not need to show a sinister motive. The law in this court is clear, right? United States v. Foxman, 87 F. 3rd at 1223 says that bad faith in this context does not require a subjective sinister motive on the part of the prosecution. That's important. Okay, we don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip. And they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time, they didn't flip. And so they waited, and because of that, we were put in a position where these records no longer exist. Now, Judge, we do argue in the alternative in this motion. And what we argue is if the court is not to dismiss the case, they should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all the call records, but they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists. And we don't have the ability to know it. With regards to the text message, we think it should be excluded. The SunPass records would clearly show whether Mrs. Adelson was at the house or not at the house.
I don't see
It would
how.
definitively show-
No, they
Well, let me
don't.
tell you why. Because you would see what SunPass records show back then, as they did now, is they show entry onto a turnpike.
Correct.
And so you would be able to see when she entered the turnpike.
Mhm.
Let me stop you there.
Yeah.
If she
Are
took the
there not
turnpike.
methods to travel and avoid the turnpike
Yes.
points?
Yes.
Where it might not be as direct, it might not be as easy. where
Absolutely.
If you enter the turnpike here, you have an easier point of access.
She could have taken 95.
But ultimately, could she have reached Mr. Adelson's home and avoided the SunPass altogether?
Yes.
Their records show she did enter the turnpike. Their own witness shows that she entered the turnpike because he's got on his many charts where he guesses, he's got her on the turnpike through a cell tower. So you don't have to guess that she entered the turnpike. You know exactly that she did enter the turnpike. Their own records show that she entered the turnpike at what's called the Dolphin Expressway. okay? So you go take 95 and you get on the turnpike at the Dolphin Expressway. That's where Dolphin Stadium is. You would first of all see on the SunPass the entrance there. And their records show that she's on that. Their cell tower records show that, okay? Their cell tower records show also timeframes on that same turnpike. Shows on their map, on their dots. They show her on the turnpike. What it can't show is if she got off the turnpike, it may not have shown her get off the turnpike, but it would have shown her get back on.
She didn't have to get back
So in
on the
other words,
turnpike, though.
If they're correct, and she had gone to Charlie Adelson's house, which she didn't, but if they're correct, at some point she would have had to exit the turnpike. Okay? It wouldn't have shown her exiting the turnpike because when you exit the turnpike, it doesn't show you exiting. But they have her at a certain point in time back on the turnpike. They would have known when she got back on the turnpike and where. And that would have showed whether she was at his house or not. Definitively, it would have shown it. We wouldn't have to guess about it. It's just how the SunPass records work.
I disagree.
It shows when you enter, and then it shows parts at the turnpike. So they're using a witness to make guesses. They have these beautiful charts where they have her pinpoint, and then they have Charlie Adelson's house, and they show that it could take from this time to this time, extra time, but they have no idea when she got off, where she got off, why she got off. And they would know for certain, 100%, we would be able to show for certain, 100%, if we had those records, whether she was at his house or not.
Excluding for one moment a future argument about Sergeant Corbett, why are these not right topics for cross-examination?
Judge, clearly if they're allowed in, they're right topics for cross-examination, but you have to do a balancing test. This is the premier piece of evidence in this case.
Really?
It is the number one piece of evidence in this case, outside your house. Because it is the only piece of evidence in this case, other than the wires, that ties Mrs. Adelson to anything after the murder. It is the only piece of evidence. We have the wires speak for themselves. We have the checks that she wrote. We're not going to argue that she didn't write the checks. This is the only piece of evidence. And they're using conjecture to get it in where if they had charged this case in a timely fashion, we would be able to show definitively she wasn't there. That's not our fault.
All right, let's go back to the U.S. Supreme Court case that is the genesis of this argument with Vasco. I believe Justice Marshall goes through the role of the prosecutor and their duties, and also discusses how the prosecutor has an affirmative duty not to charge someone before they have probable cause, to thoroughly investigate the case, and also not to clog the court system with cases they cannot prove. What is your response ultimately to this discussion as it relates to this case?
I think it's a very fair question. I think what you have to do is you have to then look at what has changed. So in other words, in doing that, that can't always be their answer, right? They can't just have a blanket answer. They have to be held accountable as to, okay, what has changed, right? And the reality is when you look at this case and you see what is going to be presented, you have the exhibit list. When you look at the exhibit list for this case and you compare it to the exhibit list in 2019, it is essentially the same exhibit list. 2019, the first trial. I'm not even talking about Charlie Adelson's trial. It is essentially the same exact exhibit list. Their exhibit list contains, essentially, against Mrs. Adelson, emails that they had back then, wires that they had back then, checks that they had back then. That's essentially their case against her. Okay? So the reality is, when you're right. They should not charge people that they don't have probable cause for. But that can't always be their answer. They have to be held to ask, well, what has changed? You know, we asked a similar question in the last trial, and their answer was dolce vita. Okay, but dolce vita doesn't apply to Mrs. Adelson. She wasn't there, right? Everything that they had in 2000, and by the way, they had dolce vita, they just didn't have a clear version of it. reality is you're going to see that 95%, probably more, of this case that we're about to hear is the same exact case as it was in 2019. Almost the same witnesses, almost the same evidence. It's the same case.
Any further argument?
No, Your Honor.
Ms. Dugan or Ms. Kappelman?
Let's go. Let's go, ladies. Bring it. All right, we have Ms.
So
Dugan
as
here.
the defense's motion states, the test here for is going to be whether substantial prejudice is caused, not just prejudice, to the defendant's right to a fair trial, and was it the product of bad faith, so that dismissal is required. The two pieces of evidence that they talk about in their motion are the phone records and the sun pass. So I wanted to quickly go through each. For phone records, he says, well, there are call patterns between the parties that occur on major events during the planning of this murder that the state presents. But every time we present this evidence, we also concede and present the fact that the people in this case, they all have relationships outside of any planning for this murder. Their boyfriend, girlfriend, their parent, child, they have children together. Those people in those relationships talk every day. That's normal and that's to be expected. And all these people do talk every day during the time that we have these phone records. Every time we've tried this case, the defense picks a random day. This is every trial we've had since 2019, I guess. Every defense attorney, picks a random day that summer and shows that, hey, there's also calls between these folks on these other days where there's not a trip to Tallahassee or some other big event in the planning of this murder to show exactly that. They've done that every time through cross-examination, and they do that without having prior records prior to May of 2014. So there's no substantial prejudice to the defendant. And there's no bad faith here. Law enforcement subbed records beginning in May of 2014 because they were trying to get records from around the time the shooting occurred in July of 2014. So a little bit before, and then also we have records after. We have records leading up to 2016 where there was no murder being planned at that time. And obviously all of the parties in this case, as we established in the case, are still in contact. They're still talking because they all have those pre-existing relationships.
Before you continue, is there a reason the records that are at issue in this motion were never pursued?
Because those are the times around the June and July trips where there was the attempt to kill and the murder of Dan Martel. We have messages between them going back before that time, but we believed, or law enforcement believed at the time that they subpoenaed those records, that was the most relevant time to the information in this case that would be relevant to this case.
Were any further subpoenas as to Sunbass or phone followed up on once the state believed it did have probable cause against Mrs. Adelson?
I believe that so getting to the SunPass records, the SunPass records, we did, I think, try to get late last year once it came to light that, can I address the SunPass records and I'll let you know kind of where it was? Okay. All right, going back to the phone records, though, this is not substantial prejudice, and it's not a situation, though, where the state purposefully did not indict Ms. Adelson until she could not get these phone records anymore. So there's no bad faith in this case. It's not a situation where we purposely didn't indict her so she couldn't get that. Moving on to the SunPass records. First of all, there's no substantial prejudice that these records would be exculpatory. As the court pointed out, we don't know if there was a way she could have avoided that. We don't know if the exit or entrance even had a transponder in 2014. In fact, given that the defendant texted Charlie Adelson outside your house, and there was a witness at trial, Catherine McVanois, who said that the defendant had been at the house that night right before she arrived, we believe the SunPass records could very well be inculpatory. And there's no bad faith here because we would actually like the SunPass records too. We did, as the court asked, we had Jason Newland make a call to try to see if we could get the SunPass records. I believe it was last fall in 2023, but we also learned that they don't have them anymore. this far late in the game. But the bad faith portion of this is only satisfied when the government makes a judgment about how to proceed with litigation to gain advantage over the defendant, and as a result, the indictment is delayed. The reason we didn't try to get the Sunpass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine McVanilla offered that information in 2023, leading up to Charlie's trial and at Charlie Adelson's trial. Catherine McVanilla mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before you continue,
Yes, sir.
was this new information learned either through the proffer or trial preparation that had never been, or never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which was all in 2023. The trial being Charlie Adelson's trial.
There you go. There you go. That's why they didn't get it.
Obviously, Donna Adelson's phone locations, right, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from, and that was this relevant to the money drop, until Catherine McVanilla said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was damp. She believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived, and that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, and we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside her house. But this wasn't a situation where we waited to indict Donna Adelson until Sunpass records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had to have been a deliberate act to gain a tactical advantage, and that's not what we have here. I also point out, Dan Rashbaum has said that he was retained in this case by Donna Adelson in 2016. Every trial that we've ever had has been, on YouTube, if anybody wants to see it, and they could have. If
Shout
they
yourselves
believe
out.
that these Sunpass records or phone records were so exonerating and obviously needed, those could have been requested prior to when they would no longer have been able to have been received.
Can the defendant, absent an active case in the subpoena of this nature?
The defense said in the last trial that he tried to get the Sunpass records and he wasn't able to before we had even thought to try to get them.
Please
I'm
continue.
not sure when he tried to do that.
If they're her own
Another thing
records,
here
he would have been
is
able to
that
get them.
If the court denies this motion, I think at that time it would become right, the state would ask that the defense not be able to argue in opening or closings or testify in their own questions that, hey, because the defendant wasn't indicted until 2023, that means law enforcement or the state attorney's office didn't believe they had enough evidence. What anyone in law enforcement or state attorney's office thinks in this case is not relevant. Given that, we believe that, obviously the dates that law enforcement received evidence, the dates that, suspects were tried or convicted, those things are all fair game and can be pointed out by the defense, but not the argument that this delay was because the state attorney's office or law enforcement didn't believe there was enough evidence to convict.
So to summarize in a nutshell,
I love
the
this
state
judge.
did not even understand what it had in the way of a text message until Catherine McVanilla's proffer.
That Catherine McVanilla's information that she provided to the state really made us
Was
zero
key.
in on that and realize that money could have been exchanged at that time by Donna Adelson to Charlie Adelson. And so obviously we always knew that they were traveling up to Tallahassee that night, the Harvey and Donna Adelson were.
After the murder took
Yes,
place.
sir, but Catherine McVanilla's information that we learned after her trial, when she began to cooperate and leading up to Charlie Adelson's trial, is what made us zero in on that.
Very well, thank you.
Yeah.
Brief response, and then we're going to move on to the other motions.
Sure. Judge, I'll do the factual point first. I was retained to represent Donna Adelson in the late summer of 2016. Okay, so I think it was the end of July, beginning of August 2016, I was retained to represent Donna Adelson. The first trial happened in 2019. When that trial happened, we tried to get SunPass records. We did. We couldn't, because we weren't an active party. We didn't have any subpoena power.
Were you stonewalled by SunPass?
They told us, yeah, exactly. Okay? When we tried to get SunPass records again was when Charles Adelson was indicted in the case. Then we were able to subpoena and try to get SunPass records. We were unable to do so because they didn't exist. So let me be clear on that. Okay? All right? The first time we were able to attempt to get SunPass records, they no longer existed. Okay? Now, with regards to them she makes a point that every counsel has picked a prior date. Let me tell you what happens. We did pick a prior date, but our universe for picking a prior date is like this big, right? And you'll recall at the last trial what happened with the prior date we picked, right? There aren't many prior dates. They found court filing on that prior date. By the way, the court filing wasn't anywhere near the time of the calls, but they found a court filing on that prior date, and they made a big showing that this is another event, right? The reality is we want to find dates in 2013, in 2012, in January of 2014, in February of 2014. None of those existed because what they did is they got records only for a 4-month period of time. And any date that we picked.
As to that point, and I understand what you're getting at, but don't defense counsel in all manner of cases all the time say the subpoena was too wide, you cast too far.
That's how you
Meaning,
try and defeat a subpoena.
the murder, what led before, what led after, there's really not a lot of argument as to the relevance. But if the state is seeking records of your client, or hypothetically any defendant, going back years in advance, are they really permitted to do that?
They don't need to go back years in advance, but they're presenting evidence in this case. Let me make 2 points to that. First of all, they got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back. Number one. Number two, they're putting emails in this case back from 2012. Why not go at least back to 2012 or at least back to 2013? They just cherry picked a 4-month period. And by the way, the records she talks about that come on later, they're related to the bump. They're not related to anything else. They're related to the bump. So yeah, they created an activity, and of course, that's going to create another pattern, right? The reality is it's unfair because they're making a pattern argument that doesn't, if it was a science experiment, it'd be a false experiment. Their sample size is too small. And we can't counter it if the records don't exist. We don't need to show that they did it we don't need to show that they indicted her after the records existed. We're not claiming that that's what they did. They made other strategic decisions to delay her indictment. And those other strategic decisions had this consequence. And because of that, if you don't dismiss the indictment, you should not allow these records to come into evidence.
Do you have any response to the effect of the proffer as it relates to the messages? Ms. McDowell's proffer, which was taken last year.
Of course, they had the message well before then. They had the outside your house message well before then. It's not, listen, when I saw it in discovery, which was before her proffer, I knew exactly what they were going to argue. It's
No.
very clear.
Of course you
didn't
did.
need her crazy argument to know what they were going to argue.
Well, let's look at this from the aspect of bad faith. Is it possible in a voluminous case file to not know what this one piece of paper actually means
Without
until a
context.
later date?
It is possible, but you have three, because there's been 3 prosecutors in this case, very fine prosecutors who have tried this case going into that case 2 times. So very unlikely. Very, very unlikely. That's what I would say. Possible? Yeah, anything's possible. But it's not that hard of a message to figure out. You have one of the key suspects in the case who you've gotten other records for, communicating with another key suspect in the case, who, by the way, in 2019, their theory was the same, that it was a murder for hire done by these two individuals. You have those key, and many text messages between the two. And you have one, and by the way, you only have like 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up outside your house, 10 minutes is the response, was not an important text message. I mean, if you believe that, I don't know, Judge. That seems a little, I'm skeptical of that.
Did they have the benefit, though, of the proffer until Ms. McDaniel gave it?
They didn't have the benefit of the proffer, but you should listen to that proffer, because she doesn't talk about the outside the house message. And by the way, in that proffer, she doesn't even really talk about what they say she talks about. She did it on the stand, but she didn't do it in the proffer. That's not my memory of the proffer. She didn't say in the proffer that, I don't believe, that they had just left the house. That's what she said on the stand. They'd already put in the outside, they'd already marked that as an exhibit. So Judge, again, the standard is lower than what they're saying. Right? It's a bad faith standard, but it doesn't need to show that they purposefully waited
I know, right, Lou?
until after the SunPass records didn't exist anymore. We're not alleging that. We don't think that that's what they did. We think they made other choices that then made it. Look, at the end of the day, Judge, what it also is you get to do a balancing test. And it's a fairness argument.
Don't tell him how to do his job. He knows what he's
Besides everything
doing.
else, it's a fairness argument.
It's clear that Vasco is rooted in due process.
Yeah, it's a fairness argument.
I'm going to reserve ruling as to this. Also, prior to making any ruling, I'm going to review the trial testimony of Ms. McDaniel concerning the outside your house text message, as I believe it does give context to what is being argued in the motion by both parties.
Mm-hmm.
Right, let's move on to the defendant's motion to hold trial in courtroom 3B.
Yes, let's go. Let me give a shout out to Kim DeLorme. Thank you so much for your generosity, Kim. I appreciate that. Thank you.
We've had a little bit of discussion about this previously. There are a couple of practical reasons.
It's the courtroom motion,
I'm
guys.
Judge of what occurred during Charlie Adelson's trial and the interactions with jury and gallery. Essentially, this motion seeks a prophylactic measure against that.
Make sure people can attend.
You're great at controlling your courtroom and being able to interact with the audience and the gallery.
But you still want a different courtroom.
Yeah.
Because you can't do your job, Judge.
Don't butter me up. Get to the point.
Get to the point.
Fair enough. Judge, where we sit at council table there, the prosecutor's table obstructs the view of jurors
Oh,
1,
please.
2, 8, and 9. There's no ability for Ms. Adelson to view those jurors. There's no ability for the jurors to view Ms. Adelson.
Get the booster
or defense
seat.
counsel. And of course, that's an important facet. Defense counsel sits here, displays here, examining a witness. You park at the prosecutor's. Last case, the relations between counsel and the defendant are posted on the internet before the lawyer can even get back to their hotel. And so it's been interesting to read the media response. This isn't a circumstance of trying to curtail the media's ability to gain access. It's a function of trying to facilitate there are fewer opportunities for problems to arise.
Fewer people equal fewer
That's
opportunities.
a practical consideration. And of course, all of this is in your discretion.
Well, I was going to say, in researching your motion, I did not come across a fundamental statutory or procedural right to be tried in a particular courtroom.
There
Do
isn't.
you have one to argue today?
Nope.
No, I do not. It's a due process argument and an argument of prophylactic measures to protect against. And then there's the last component, which I've tried many cases in the courtroom, multi-co-defendant cases in the courtroom. All of them are different. The acoustics in this room are rough sometimes.
Oh,
But
dear
from
me.
the number of inmates that we potentially have testifying in the case and the movements of people.
Yes.
He is trying everything,
it's
you
not my
guys.
challenge, It's the bailiff's challenge. There are security issues, and I know that it's difficult here. Courtroom 3B is smaller and more compact. I know that someone has mentioned that there are technological concerns of it being antiquated. No better time for us to ask court admin for an upgrade.
You guys, he's
Get
trying.
To be able to put a machine in that works appropriately. There's really a functionality and a practicality argument to make sure that we best protect Ms. Adelson from things that we've seen occur previously.
Very well. What you raise about counsel table, when we do have co-defendant trials in this room, the second table is added. It is the defense's preference to ultimately have what would be considered as the co-defendant's table and face the jury for the duration of the trial.
I think we're, irrespective of which courtroom, I think that we would need a second table anyways. We have one additional person sitting at counsel table with us during the trial, so there would be 4. So we'd have the traditional L, if you
Ooh, who
will,
else?
from whether it be in 3B or here.
Maybe a paralegal.
It's a little bit more difficult here because of the configuration to be able to put that many people, but
Desperation and begging, Judy.
yes,
You're
I'd
right.
like to be facing the jury, but 3B, I guess.
Very well. Response from the state as to this motion.
I can see where the judge is going with this, I think.
Yes, sir. Yesterday, a letter was sent by the Martell family stating their reasons they wanted to remain in 3G. Did the court receive that?
I was
Wonderful.
able to review it. There were also some other letters that I received either from concerned parties that were forwarded.
Yes.
I believe the state and defense as well. Did everyone receive the letters of the concerned parties?
Yes, sir.
You may continue.
Aside from those letters, just from the prosecution's perspective, the primary reason for us asking that it remain in 3G is just from a practicality standpoint of presenting the case. You know, in 3G, we have the big screen overhead. We have the multiple screens in the jury box for the individual jurors. We have an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector that from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes the state has to actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and the court
You know
knows.
I hate that television.
Right, it's a pain. And so, being in 3G isn't just something that we do or we've asked for. In this case, we asked for it in all cases where we have a lot of visual evidence to be shown. In this case, we have surveillance video, cell phone records, maps, texts, emails, financial records with graphs and charts and electronic wire transcripts and other visual demonstratives that I think will be much easier for the jury to see and understand if the trial is in 3G.
Great points.
In the defense motion, they bring up, the inability to see the box that the judge has already, or the court's already addressed. They also bring up the lectern placement as an optimal. I routinely will move the lectern with the microphone over to the projector so that I can operate the projector, or have my laptop up here on the lectern so that I can use my laptop and have it on the big screen so that I'm still at the lectern and not, and can move it about. And I think that should solve their problem, the ability to move this lectern around.
Obviously.
Finally, I just want to point out that, the defense is concerned about juror distraction. However, in 3B, the jury box is extremely close to the gallery. So I think that there's a risk for distraction there as well. And I think that the court in the last trial, through instructions to the jury, and through, making sure there was no cell phones used, was able to remedy that.
Very well. Prepared to rule on this issue today.
Fantastic.
I believe as the final jury instructions make clear, the jury will be instructed that they are to decide this matter based on the nature and quality of the evidence presented. The court is going to take all means necessary to avoid there being any distractions from persons present, sitting in the gallery, or attempting to improperly influence the jury in some manner. The examples that were cited by the defense, the court is not taking lightly. At the same time, the court does not have a way to ultimately prevent what is being complained of in the motion from happening in any courtroom. I am
Yeah.
going to be very diligent and also very thorough in the deployment of the bailiffs as it results in this matter. The court also will take all suggestion from the defense.
We're in
as it
3G,
relates
guys.
to the placement of the table, so the defendant can be clearly seen by the jurors throughout the trial. As to the placement of seating on the defense side, ultimately, any observers or onlookers in the gallery are going to be placed at least 2 or 3 pews behind the defense, so that way there can be no attempts to either photograph or record the defense's interactions with each other, with Mrs. Adelson, or attempt to get any snippets of papers or other matters. Concerning the media and also any onlookers, I'm really not going to get into why people wish to come, if they have a legitimate interest or if it's just a curiosity for them. The Constitution provides that the courtroom will be open.
Thank you.
Unless there is a statutory or otherwise basis for closing the courtroom or excluding persons, the courtroom is considered open. However, the conduct of those persons, the court will closely monitor. Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around. The defendant's motion to move the
Denied.
trial to courtroom 3B is denied.
Denied.
And this is also for practical purposes
All
as
right.
well. Courtroom 3G is the most recently renovated courtroom in the Leon County Courthouse. It has technology options that are unavailable in the other courtrooms, and it is also best capable of accommodating the needs of this trial itself. If the state can prepare an order or defense as to the denial. Let's move on to the defendant's motion to suppress wiretap interceptions.
Judge, I'm definitely not going to belabor this motion. It
Where's
is
the milk crate?
Same exact motion that was
Blue
filed
wants to
in
know.
the last trial. It was denied in the last trial. The only difference in this motion is we have a
We'll
section
just keep this
where
here,
it
Judy.
shows that Ms. Adelson has standing to make this motion. So Judge, I'm just going to rest on the papers. It's a preservation motion. We respect your judge's ruling previously, and I don't think, unless you want me to answer any questions.
I don't believe the state is contesting the standing of the defendant to raise this issue, correct?
Correct, Your Honor.
Does the state have any additional argument to make concerning those?
Judge, I do have a couple things I think I should put on the record, so we're not relying on your previous ruling in this case.
Go ahead.
Welcome, Georgia. Look at that beautiful green color on her.
Well, as to
Love it.
certain findings or conclusions of law as to my review of Judge Hankinson's authorization, those to a certain extent I will be relying on, but I'll allow you to continue to make your argument.
Yes, sir, I just want to put a couple things on the record regarding the standard for, it's alleged in the motion that necessity is a standard, and truly that's not the case pursuant to Phillips v. State 346 Southern 3rd 1252. Exhaustion and the objective of the criminal investigation are the standard, and in this case we have met that standard by showing that other investigative efforts have tried and failed, or are too dangerous, or that this wiretap in this case was the most reasonable investigative technique under the circumstances. Regarding the objectives of the conspiracy, in this case, the objectives of the wire, in this case, it was to reveal the identity of the conspirators and their role in the conspiracy, so the structure of the conspiracy, and that's permissible under McGuire v. State 307 Federal 3rd 1192. That's a 2002 case. So here again, we're trying to identify the persons involved and gather sufficient reliable evidence to prove beyond a reasonable doubt what their roles are, what's the hierarchy of the conspiracy, is there any additional physical evidence that can be gleaned in this case, any information regarding monies or assets or other things of value. Regarding the staleness issue that's raised in the motion, I did want to point out a couple things. We note that the issue of staleness cannot be solved by a simple application of numbers of days without consideration for the overall particular circumstances presented in this case. Here, the circumstances of this investigation required efforts that involved a lot of record gathering and waiting for records and receiving records and analyzing them before we got to the point where we had reached exhaustion and were looking to seek a wiretap. The state's subpoena served on 12/14 of 15 requested a bunch of records between 14 and 15. Those were received in 16, including this defendant's checking account. We then subpoenaed a bunch of different Adelson accounts, that, including the one that the checks came from, and those were not received until 3/1 of 16. So, you know, that accounts for the timing. And there's a case that talks about, did I get it for you? Delay being appropriate in conspiracy cases, or more leeway being given in conspiracy cases because of the nature of the investigation. It's going to take more time. And I think that is, yeah, State v. McGuire, and Judge, that's at, I'm sorry, it's US v. McGuire 307 Federal 3rd 1192, and that's 2002 case, which I already cited. Sorry to do that twice. But that case specifically talks about the government being entitled to more leeway in its investigative methods when it's pursuing a conspiracy, as it acknowledges that's a different type of case, different type of investigation. Lastly, Judge, I just want to touch on the issue of fresh evidence. You know, as mentioned in the application for the wiretap, law enforcement anticipated the use of an undercover operative in conjunction with this wire, because in doing so would produce the fresh results that chatter on the wire. And fresh new evidence among these co-conspirators. The chatter that occurred between them to handle the blackmailer was brand new communication that could only be intercepted using this wiretap. With this new evidence, the argument of stale probable cause becomes moot, because the new evidence was being created at the time that the wire was up and the communications were being intercepted. And there's a discussion of this fresh evidence and the importance of gathering fresh evidence in US v. Maestas, MAESTAS, 2016 Westlaw 9725188. So that was all I was going to put on the record, unless Your Honor had some questions for me or wanted me to put anything else.
No additional questions. As to the application for the wiretap, did the defense have any additional exhibits that were previously not provided during the Charlie Adelson motion hearing or for this motion?
No, Your Honor.
Very well. The court will file its written order in this matter. Let's move on from here.
Judge, can we just ask that those exhibits be incorporated in the record here?
Yes.
Thank you, Your Honor.
All right, let's move on next to the defendant's motion to use a jury questionnaire.
How is Donna processing having to be questioned by Georgia? Only if she takes a stand.
The law says that it's discretionary. I think Judge Neff is doing one this week or this coming week, if I'm not mistaken.
Homicide?
Yes, sir. I saw some email traffic from Ms. Gaston with respect to it, but The objective is for jurors to come in, not talk about, hey, what do you think that we're here for, and what's your opinion on what we're here for, and let's discuss the case. And if we're able to have them focus on the answers of the questionnaires and then submit it, the defense feels like we're miles ahead in terms of information gained, decreasing the possibility of tainting the venire or the pool, and being able to hone in quicker on issues. Now, all of the questions, Your Honor may take exception to some of them, the state may take exception to some of them,
As they should.
Recrafted, made shorter, but the overall goal is to see if we can get more information in the door before we have to start doing work with them.
So from the procedure that was used by both myself and Judge Wheeler, and I believe also Judge Hankinson, is there a particular thing that you're pointing to that otherwise negatively affected getting a jury?
I think there were instances have been brought to my attention, and I think it became evident in Charlie Adelson's trial that the jurors had been downstairs once they got up here. They had been downstairs, and that there was communication amongst them about the very thing that I was mentioning. Why are we here? What's your opinion on this?
Well, what do you expect?
They also did not remain.
I'm sorry.
They also did not remain.
Understood.
I'll put
There's
it
no
this way.
answer.
If you can't follow instructions at the outset,
You're not going to follow them
there's no reason to keep going with
during the
you.
trial.
If anyone that I find in that way,
You're on my.
don't worry about them being on the jury. Go ahead.
Are there additional instances of problems? I don't think my answer is yes, there are additional problems. I think it's a circumstance to be able to make it better and make it work more efficiently.
Very well. Response?
The state objects to using the question. I think, I'd like to hear and see these jurors answering the questions that the court asked last time. Sometimes it's just as important to see like how someone answers the questions and their body language and what they say and how they say it, as it is to hear the words that they're saying. So we'd like to not have one for that reason. Also, we just don't believe that it would save as much time and be as efficient as the defense thinks it may be. I think we have to litigate, well, what does it look like? And both sides are going to want something different. And then we've got 5 or 6 pieces of paper for each juror that the juror then probably ends up getting asked about anyway. So the state would object to it for those reasons.
Very well.
Mm-hmm.
As to this motion, the court will rule on it now.
Great.
The court is going to deny the motion, and again, looking at this on practical grounds, ultimately, there is going to be examination by the court on the issues of pretrial publicity and hardship to serve in a trial of this length. The ability to engage an individual venire with the entire venire that has been summoned will sufficiently accomplish the goals of the jury selection. Both parties will be able to follow up on the court's questions. Additionally, as well, as my memory serves from the Charlie Adelson jury selection, several individuals who either were going to be cause challenges or other issues were discovered, such as them seeking to gain admission to the jury, were thoroughly rooted out during the process. In that way, this will work the same for Mrs. Adelson as well. Anyone who is biased or anyone who is trying to gain access to the panel improperly, we are going to get to the bottom of it. The process has worked. I believe it will work again.
Denied.
All right, let's move on to the defendant's motion in limine.
They're not doing so well this morning.
As to the first prong, testimony concerning pre-arrest silence, the motion indicates that the state is not opposing this. Does the state have any additional argument, or is the condition changed?
No, sir.
Defendant's motion in limine is granted as to prong 1. As to prong 2, wealth evidence, you may make your argument.
Okay, Judge, as you may recall, the state intends to call Mary Hall as a summary witness. I say summary witness because in the past she's been an expert witness, but I don't think she's an expert. That's for another day. But
Wow,
as a
they're
summary
challenging her
witness
as
to
an
talk about
expert.
Wealth records. If you recall, they put in records showing the combined wealth of the Adelsons. They go through a bunch of accounts and they show what their combined wealth was. Judge, we think this is clear that under U.S. v. Bradley, that evidence of the defendant's wealth may be admissible, quote, when relevant to issues in the case, but that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. Okay? This is clearly coming in for that purpose. Their wealth has no bearing on the issue in this case of whether Mrs. Adelson participated in a premeditated murder. There is no dispute in this case. We will stipulate into it that checks were paid out of the Adelson Institute.
That was going to be my first question. And as to your general proposition, I would say you're correct on the law in the same way. The jury is not to consider that a defendant is indigent and hold that against them. It would equally apply to wealth. As it relates to the state's theory of the case, is there any relevant evidence of wealth that you're still disputing?
No. I mean, the argument in this case is that she paid for a murder, and that is not our dispute. I mean, we're disputing it was for a murder, but we're not disputing that she signed the checks. We're not disputing that the checks came from the Adelson Institute. And we're not disputing that $100,000 was paid to Catherine Magbanua on the night of July 18, 2014. July 18, 2014. We're not disputing any of that. We're not disputing that they had the ability to pay the money either.
Was there other evidence as to transfers of vehicles or other property
We're not
that
just.
is alleged to have been given to Ms. Magbanua?
There's evidence of a car that was given to Ms. Magbanua that was in Harvey Adelson's name. We will not dispute that either. Again,
So
The jury needs to know this.
generally, these are wealthy people, not the specific matters that are being alleged a part of the conspiracy or payment for the conspiracy.
we're not disputing any of that. So, and why do they need to show a wealth of millions of dollars? You know, and they spend a lot of time on it, millions upon millions of dollars. What is that relevant to? I don't think it survives 401. But if you go to 403, it certainly doesn't survive that.
Response, State?
Judge, this is a murder for hire. The state's entitled to prove that this defendant had the means to make the payments that are alleged, to make the payoffs that are alleged, to buy the cars, property, etc., gifts, etc., that are alleged to have been received by the killers. And it's relevant to show that they have the ability to make the $1 million proposed bribe that preceded the death of Mr. Markell. It's important to show the means relative to the payoff. So this was a drop in the bucket, right? That's important, I think, for the jury to understand the motive and the means and how this was executed.
Very well. As to this particular point, it will be granted in part and denied in part. As to evidence which specifically demonstrates that either Mrs. Adelson or one of the other co-conspirators used assets to pay Catherine Magbanua or other members of the conspiracy, the state is going to be permitted to demonstrate that evidence. As far as any general presentation, however, as to all assets of the defendant, that is where the line is going to be drawn. As to Mrs. Hull being examined on whether the defendant had adequate assets to otherwise participate in what would be called the $1 million bribe, or is alleged to be the $1 million bribe, the court will permit that.
All right.
And just going into a general examination of all of their assets as to showing in some sort of way to create a wealth bias, the motion is granted in that aspect. If
I don't
to
think we
get
need
more
that.
Specifically into which pieces will be used, we can do so. Are there questions as to the ruling?
May I have a moment to confirm?
Go ahead.
Judge, may I make something clear too that might help? We're not going to dispute the $1 million offer. In fact, we're going to bring it out. So that won't be an issue.
Yeah, I don't think they can hamstring us by stipulating the thing.
Mhm.
So,
You don't have to accept their stipulation. I believe this much is clear as a matter of trial practice.
let me just confer with counsel about the financial evidence and see if there's any clarifications.
So stipulation is both parties agreeing to a certain fact or facts. And when something is stipulated, the judge will explain the stipulation to the jury, and the parties don't have to put forth the evidence themselves. We saw stipulation in the trial, in Charlie's trial, about the
Am I
times.
correct, Your Honor, that if we're inquiring
One
of the
second.
witness, Paul, about the time frame in which, say, the $1 million offer was being proposed, we would be permitted to ask the witness, what did you analyze, what did you look at, and did the defendant have the means to make that payment at that time? But we would not be permitted to say what was the bottom line in her bank account at that date.
Correct. That examination will be permitted. What would not be permitted is to say the defendant had $10 million at TD Bank on this date. I believe that's ultimately what the defense's motion goes to. Am I correct?
That's correct, Your Honor.
So the stipulation that I was talking about before was a stipulation of what times the children were dropped off and picked up at their preschool on the week of their murder, actually, of Dan Markel's murder. That's just an example of a stipulation. Yeah, I agree, Judy.
Let's move on to number 3, hearsay testimony from Jeffrey Lacoste.
Okay.
Definitely not Pat Sanford.
Not as complicated as you think. Just make your argument.
All right. So, Judge, in the last trial, we filed a similar motion.
They do not want Jeff Lacoste
In our
testifying.
favor. You excluded the hearsay testimony as being just that, hearsay testimony. Okay? And what proceeded to happen, as we all know, is the state then asked the question of this piece of evidence, of these statements, to Wendy Adelson. Wendy Adelson denied that she ever said these things, and then they were able to backdoor it in through impeachment. Okay?
As you can.
Well, I wouldn't consider it as a backdoor as much as,
Impeachment.
would you agree with me, there are often times when it comes to evidence, may not be admitted for one purpose,
But it can for another.
not exclude its use in other ways.
I
You're
would
right,
agree with that
Judge.
statement, but I would disagree that it wasn't a backdoor. But nonetheless,
Go ahead.
Oh, Rash, stop it.
this is different because the question to Wendy Adelson in the outset trial was about a statement that Charlie Adelson made. So it fit an exception to the hearsay rule, which was it was a statement of a party opponent. Okay? In this case, the statement, if they ask Wendy Adelson the question in the outset, it doesn't fit such an exception. It's not a statement of a party opponent. Asking Wendy Adelson what Charlie Adelson said is still hearsay because Donna Adelson is the party opponent. And it's not a statement in furtherance of the conspiracy because none of this had to do with any conspiracy statement in furtherance of the conspiracy to commit a murder. None of these statements are in furtherance of conspiracy. So what I'm trying to say in short order is, number one, we assume you're going to rule the same way, that it was hearsay, and prevent it from coming in through Jeff Lacoste. And what we're also arguing is that it should come in through Wendy Adelson because that is also hearsay. It's hearsay because it doesn't fit an exception. That it would have in Charlie Adelson's trial. It doesn't fit any exception in this trial. And so we're asking that it not come in at all. Now, when you look at the statements, they're all a little bit different. Buying her a television was cheaper than a hitman. that Charlie Adelson actually looked into possibly hiring a hitman, and then that Charlie Adelson described the dinner as a celebration. That's even after the murder. So that's even, and then Charlie Adelson kept large amounts of cash in his home, right? These are all statements that are hearsay, right? They're hearsay if asked of Jeff Lacoste, and they're hearsay if asked of Wendy Adelson. And as a result, they shouldn't be allowed to be asked or admitted.
Response from the state?
Do we have a hearsay exception here?
For Your Honor, I think these are statements against interest, these are
One
statements.
moment. I need to remove some people from the Zoom.
Yes, sir.
That's a big question. Is Harvey going to show up at the courthouse?
Go ahead.
Just another Smith. We need answers about this parrot.
Conspiracy, Your Honor. If Charlie is telling the main beneficiary of this murder that he's looked into hiring a hitman, that's in furtherance of the conspiracy. And how much it's going to cost, too, was part of the statement. That Charlie Adelson had, in fact, in the summer of 2013, begun looking into hiring a hitman to kill Dan Markel, and the cost was either going to be $15,000 or $50,000. One of the two, she said, as you will recall. How can that not be in furtherance of the conspiracy, right? If Wendy denies it, then it's textbook impeachment to call the person that she said it to indicate that she said it.
And that is your argument as to all four of the statements that are being highlighted.
Yes, Your Honor.
Well, I'll reserve ruling on this topic for now. I'll do some additional research as to statements in furtherance of the conspiracy. Let's move on to number 4. Testimony from Wendy Adelson.
And Judge, with regards to number 4, the state's position may or may not have changed on some of these. So I just want to let you know that at the outset. They let me know recently that their positions were possibly changing. So
Interesting.
so here we're trying to prevent certain statements, certain questions from being asked to Wendy Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial.
I mean, her autobiography.
The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes had anything to do with Donna Adelson. We don't know how that could have anything to do, again, with this case. The third is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice a jury. And so under a standard of 403, they should not be allowed.
I mean, they absolutely make everybody involved look
Also,
guilty.
one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes and the validity of.
Thank you.
Is everyone clear on this?
Yes, Your Honor.
Go ahead, Ms. Copeland.
I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendy Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time that testimony opened the door to her having written a clearly autobiographical
Yes.
book about a a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to the other two items, I think those go to the state's theory that this crime was done in order for Wendy to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right. As to that point, Ms. Kappelman, I understand the relocation and the divorce proceedings as it plays into the state's theory. But ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain parental decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant to the state's theory in the murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father, right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further argument as to this issue?
No, Your Honor.
Just one briefly.
Go ahead.
Wendy Adelson isn't on trial. So, I mean, this may be a different topic if this were the trial of Wendy Adelson, but this is the trial
It will
of
be
Donna
soon.
Adelson. And what they're trying
Hopefully.
to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendy Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Ron, for any of these things.
What do you think, you guys? Are they in or out?
As to sub-prongs 3 and 4 of number 4 of the defendant's motion and remedy, I will grant that. As to prongs 1 and 2, I will give additional consideration to the argument that's been made. I will reserve ruling as to those sub-prongs from now.
Thank you, Ron.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay, and it's certainly not in furtherance of a conspiracy. This is after his conviction. So we're only talking about, let me be clear, we're only talking about jailhouse recordings after Charlie Adelson is convicted. So there are
The Vietnam
recordings
recording.
in this case that I believe the state intends to use. I don't know, where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. It's an exception to the hearsay. It's not hearsay, but Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy. And some of the statements are inflaming.
Are any of these in any way tied to this issue of travel as consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think
Yes.
there are statements where Charlie is talking about his trial, and Charlie is talking about why he believes he was convicted, and Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using, but Charlie's statements are not admissible.
Right, state response.
Maybe they're not being admitted for the truth. In that case, it wouldn't be hearsay. Let's see what the state has to say.
These are statements against interest that are made by Donna Adelson or are adopted by Donna Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter of what you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think you all know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where
This was
Charlie
on the loan application.
yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show, like, this is what's happening. It's a call where he's dropping off. She's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
I thought those are all in the hot mic call.
Best before I rule on this.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction as it relates at least to law enforcement and a defendant's interview, is your argument essentially this goes to the context of the call?
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well. I'll need to review these calls before I can actually make a ruling on, because as the defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problems and we have relevance problems. Ultimately, I assume anything the state would be seeking to admit is going to meet a relevance threshold. From there, whether playing the entire context of it would otherwise get over the hearsay issue, that I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context in a recording. I will read the sample instruction to the parties. You also may propose any suggestions.
We've heard those instructions before.
But ultimately, it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of the defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You are not to consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses.
Mm-hmm.
That ultimately, if any will be admitted at all, that will be subject to that instruction to the jury. So it is clear, Mr. Rauschbaum. So it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. What? Last prong, autopsy photos.
They're going to say,
So Judge, the
we're not arguing
court has held
that didn't happen.
Autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay? In
We're
this
not
case,
disputing.
There is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I might be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 x-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that, again, I think it's a balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
No, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
they haven't done that in the past, but we don't intend on attacking his credibility when it comes to how the murder was done.
State, you may respond.
Judge, this is a material issue that the state's required to prove that the
Probably.
victim is in fact dead. We don't have to accept a stipulation. Photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were x-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the sibling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Well, as to this point, I will find that the value of the autopsy photos are probative and the prejudicial effect does not outweigh them. The motion is denied as to this particular point. Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
Here we go, guys. This is a big one.
So Judge, I think our motion to some degree speaks for itself.
She was fleeing,
In this case,
and you advised
the
her.
state
Yes.
went to tremendous means to try to wait to arrest Mrs. Adelson until she had to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in Florida. We were unable to find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again.
No.
I think we've beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know, I'm far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity? In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases, those couple cases that I cited. And here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers about it. Okay? You're
Why
going to see
doesn't he
that
say himself?
to make sure that she wasn't committing a crime. You're going to see that she used her own passport. You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to Mexico or fly to San Antonio, walk across the border, go. You're going to see that everything was pretty open and notorious, things that would contradict flight. And so,
Let me stop you there.
yes,
Please.
Does flight have to be surreptitious?
it doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances. When you're determining whether it goes to consciousness of guilt, flight is a component, right? If for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight. When you look at the
Yes.
totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say
He just
7,
needed to get it
after
done.
She's a suspect. You see that she's traveled many, many times and always come back, right? So, and by the way,
Not in the same
you hear phone
circumstances.
calls. Their phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going and what she's doing, right? And so, look, consciousness of guilt is a very, look, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented
Wow.
based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions. But I'm here.
Well, is
No
there
way.
any other evidence that puts context on this travel?
Is there any other evidence that puts context on this travel? I'm not sure I'm understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things that otherwise go to, this is not just the purchase of a flight?
Yeah.
Sure.
Why is
There-
judge
there-
having to
there are
ask this?
pieces of evidence that I believe the state intends to try to admit that would show both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that.
Why didn't you raise that?
That, one moment.
Sure.
Yeah, I will. There is evidence of that for sure. But again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and what's the actor's name?
What are the explanations?
Yeah, Harrison Ford running around in Southeast Asia for the rest of their lives. But we think that when you do your balancing test, prejudice outweighed. We'd also say this, and this, my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. That Vietnam villa is an investment done, as they know, they've spoken, it's their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual that individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it.
Well, bring in the evidence of that.
Villa,
That's under the rules of Vietnam.
no, it's like a timeshare. So even when you own it, you can only live in it for 6 days. And so when Charlie Adelson is arrested, Donna Adelson and Harvey Adelson continue to make payments for that villa because that's the agreement they have with Scott Radius, and if not, they lost the prior payments. It leads to, look, this consciousness of guilt argument leads to a lot of...
Save it for
nonsense,
cross-examination.
to be honest with you. And we think that when you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it is allowed in, we'll probably ask for some sort of limiting instruction. But Judge, we think that it does fit, the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails.
State.
This is exactly what a jury needs to decide. A finder of fact needs to decide. Given all these facts, all the
There's
evidence,
as many factors
it's up to them.
that suggest that this was for flight, was a matter that was demonstrating consciousness of guilt as the ones that they plan to argue. She was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. The state feels that's relevant. If it's anything that the defense wants to argue and the facts that they've pointed out are the fair game for cross-examination.
Exactly.
They are free to elicit those, and we can have a dispute. Let the jury decide.
Exactly.
What the evidence shows and what the weight is rather than admissibility. But how is it a 403 problem if she's just going on a vacation and that's what they're going to show? What's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
As to this motion, I am prepared to rule.
Here we go.
I reviewed the cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. The motion is going to be denied.
Denied.
I believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury, is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid
Look at Donna.
prosecution.
Look at Donna.
This is consciousness of guilt.
Look at her
Really,
face.
it's not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that the defense would seek, you may submit that
Proposed.
concerning this issue.
Who gets a one-way ticket for
I
vacation?
believe that covers the defense motions for today. Rashbaum, if you can submit orders, at least for the matters that have been ruled upon concerning these matters. Let's move to the state's motion in limine. As to prong one, Ms. Kappelman.
Yes, Your Honor. As we have done previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts as irrelevant and bad character evidence. Did you want me just to address prong one?
One for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor. I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong one?
Well, I mean, I think we're going to have to bring up the Latin Kings. I mean, they inserted it. We weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with a gang, did it not? It's just the name Latin Kings wasn't used.
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings is a relevant fact that was actually inserted by the state in their bump operation, right? The whole point of the bump is someone's approaching Mrs. Adelson, who is supposedly also a member of the gang, and is speaking on behalf of Mr. Rivera, who wants to get paid,
Latin.
right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, how many rapes he's done,
So the name is the identifier, that is what you're seeking to make use of.
Of course.
Ms. Kappelman, a response as to the use of the name of the group.
I do not agree that the name is in the evidence that the state intends to produce. So if that's your honor's ruling, which we would request, then criminal street gang could be substituted for Latin.
Judge, we would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Miss Adelson hears that the guy
As one gang has greater credibility.
What does he know about
certainly
this?
does in Miami,
What does he know about gang
right?
life?
So when Miss Adelson hears that the Latin Kings are behind this, I mean, that's what she hears at some point. That's what the evidence is going to be. It affects how she does certain things, right? And so, we think that is relevant and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also once again permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve ruling as to that. Specifically, again, in what context beyond hearing she knew he was a gang member are you planning to use this or present this to the jury, Mr. Rashbaum?
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this was a particular chapter that he was in charge of. Is that what you're getting
Correct.
A
at?
nonprofit.
Ms. Kappelman.
We just think it's prejudicial, more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin king. She knew there were gang members that were threatening to kill, is what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin king.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin Kings, I'm going to reserve on that issue for now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin Kings in it, we will approach.
Correct.
Thank you.
States prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kappelman.
You're gonna have to look these up, guys. I don't have the motions in front of me.
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred. So I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
Response?
We don't plan on doing this, unless something crazy happens in court. Then we'll approach Your Honor and, we'll discuss it then, but we don't plan on proactively talking about it next trial.
Very well. Prong 3 is granted. Counsel for the defense is directed to alert the court should you believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor, we've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kappelman, you may make your argument.
Yes, Your Honor. The state has prepared demonstrative aids, which combine video footage, clarified audio recording, and transcripts into one item that we'd like to present to the jury for both the Dolce Vita recording as well as the Matsuri recording. So those are mentioned in paragraphs 4 and 6. We also have similar to what we've used previously with the wiretap calls. Slides that have the scrolling transcript along with a photo of who's speaking, which we think assists the jury in understanding those items of evidence. I think that was all that was covered in these. Yeah, so Dolce Vita, Matsuri, and the wire calls. We did previously have an objection to any editing, any underlining or any highlights, which we have removed from those exhibits. So those will not be present.
Well, response?
Our position is the same as in the last trial. We don't object to the transcripts from the wire. We do object to transcripts for Dolce Vita and Matsuri due to audibility. And last time, I think the judge ruled with us and ruled that the transcripts would come in for the wire, but not for Dolce Vita or for Matsuri, and that's our position today as well.
I reviewed the recordings of both Dolce Vita and Matsuri once again. The issue that I keep coming back around to on this, Ms. Kappelman, is ultimately for a recording that does have some limitations or issues. How does the transcript not otherwise suggest the person or jurors who need to listen to and interpret it, what is on the recording if they themselves are not able to make it out clearly?
We do have and had in the last trial as well the authentication of the transcript by a party who was present for the conversation. I think that's what made the difference in reference to the Dolce transcript use in the last trial. We were able to use that. Matsuri was out. The defense is correct on that. That could potentially change.
Is that witness going to authenticate then the transcript itself?
Yes, Your Honor.
Mr. Rashbaum, any remaining arguments concerning them?
Yeah, you still can't hear tons of the transcript, and they're guessing as to words on tons of the transcript, and you still can't hear the first 31 minutes because they didn't record it. And they have a recording of those 31 minutes, but they didn't include it. So it should be, look, the standard is, in situations like this, you leave it up to the juries to hear what they hear. We're actually not moving to preclude the audio, we're precluding a transcript, right? And the law is pretty clear that it's up to the jury to hear what they hear and make a decision based on that and not what the state thinks they hear.
I agree with you, that aspect is clear. The additional portion of the witness who will swear that the transcript is authentic, what is your argument to that?
I mean, but every other word of the transcript is unintelligible. UI. So, I mean, that should not come in. You can hear some of those UIs. Sure, I can cross the witness, but do we really want to go through that when it's very easy that they just hear what they hear? That's the default.
Very well. This will be granted in part and denied in part. As to any transcript for Matsuri, which there is no authentication available by any witness, that transcript will not be presented to the jury. The jury is to determine for themselves what they believe the recording holds. As to any use of transcripts as a demonstrative with the wiretap calls, that will be permitted. As to the use of any transcript relating to Dolce Vita, that will be subject to a proper foundation and authentication being made by the witness. The defense may challenge the foundation and authentication by the witness. However, if the proper foundation is laid at that point, this is no longer guesswork as it relates to the transcript. The parts that are unintelligible cannot be misrepresented in any way. The witness may not misrepresent the parts that are unintelligible. However, to the extent the witness can say, this is what was said during the meeting, that is a proper foundation basis for that testimony, for that evidence to be presented to the jury. That is the ruling as to that item. All right, let's move on to states. Prong 8, statements to elicit sympathy for the defendant.
Lou, you're
Yes,
too
Your
funny.
Honor, we had a prior hearing during the pendency of this case where some issues came to light regarding the defendant's allegations of how she was being treated at the jail. I've conferred with the defense on this, who's advised they do think that that type of reference and material would be admissible in this trial. As such, I would move to exclude any reference to the conditions in the jail as irrelevant under 401 and basically just being offered to inflame the sympathies or passions of the jury and more prejudicial than probative under 403.
What would this be offered for by the defense?
I don't plan on offering it. It depends, though, what comes up at trial, right? So, including consciousness of guilt, because it goes into why someone might do what she did to avoid being in jail, waiting a trial, right?
Oh my God.
Again, I don't plan
Really?
on doing it. We don't plan on doing it openly, and we would come to you before we did it, but I didn't want to agree to it because I don't know what's going to come up at trial, right? So it's certainly not going to be something we do without notifying the court first, and I don't expect to do it.
Well, as an important proposition of law, jail sucks. However, why it become relevant, but jail sucks, that's still the question.
I think everybody knows that.
Again, as I stand
Jail
here
sucks.
today, we don't plan on doing it. But if we think it becomes relevant, we'll certainly bring it to the court's attention before we do anything like it.
Very well. Prong 8 is going to be granted subject to any proper or relevant basis in which this evidence could be examined upon. Counsel for the defense at the appropriate time will need to raise why they think a relevant basis has occurred, and ultimately a proffer will be taken as a present to the jury.
Just another Smith. I haven't
That
seen
takes us
anything
through
trying body cam
this
videos.
morning, other than the other outstanding motion involving Sergeant Corbett. Are any other motions being anticipated by the defense or state concerning the exchange of witness list exhibits?
Then you? perhaps?
That did happen, Judge, and we are still in communication about small changes that are happening, and we'll bring it to your attention if we have any issues. But so far, we're getting along okay on exhibits and witnesses. There's still a couple depositions outstanding, which we're working on, so no issues to report at this time. We do want to approach on one other matter, though, before we are done for the day.
All right. Mr. Morris?
Judge, on demonstratives, and when I say demonstratives, I want to make sure that I understand what you're talking about, understand what I'm talking about. I've got some flow charts or timelines that I'm constructing. They're not finished or complete yet, and importantly, I don't think they're going to be on Tuesday. I addressed that issue because that's the deadline that we've set. I addressed that issue with Ms. Kappelman yesterday. She indicated that she had similar timelines. We both agreed, with your Honor's permission, that we're okay not being constrained by the deadline insofar as we share with one another prior to the trial. That way, if there are any issues, we're able to discuss those. In other words, no surprises. So the first thing I ask is for your permission to let us manage ourselves, I guess, to a degree. I think that we're in a good position to do that. And what we're discussing as demonstratives are not contentious issues. They're not argumentative issues. I don't believe on the timeline issues. Second issue is because discovery, because of the depositions, there have been a couple of things that have come up. We're working through those in terms of whether there would be additional motions to eliminate. And when we approach, you'll have a better understanding of it. But that's basically where we're at. Everybody's working, playing fine in the sandbox together, so to speak.
Very well. I would just ask for a status update on September 6th when we have the next hearing as to Sergeant Corbett's testimony and his presentation. It's not that I do not trust you all, but as I've found in the course of my many years on the bench, everyone's saying all is fine until all is not fine.
Sure.
We'll discuss it on September 6th.
Murray James, yes,
City
you're
Mayor
correct. That is the Tallahassee attorney. All right. So we are over with this particular hearing. We see Donna Adelson. She doesn't look particularly pleased. She had several motions ruled against her today. They did win a few, but I think some of the major ones were denied by Judge Everett. Who said I like listening to Judge Everett? Just Another Smith. I love listening to Judge Everett. And you know what? I do too. I really enjoy how he really has a measured approach in his rulings and in his explanations and his questions. If you listen to his questions, he asks the pivotal questions that really go to the heart of the matter. So let me shout out Just Another Smith. Thank you for that $9.99 donation. I really appreciate that. Let us know, what's the name of your parrot? Because this parrot is over here typing. What's your parrot's name? Thank you so much. And thank you, Kim Delorme. I really appreciate that. This is actually, I think this is the very first hearing that I am streaming with you guys. So practice makes perfect. I want to get it just right. I was planning on streaming the trial in whole or in part. Looks like I'll be going to Tallahassee because the defendant's motion to hold the trial in the smaller of the two courtrooms was denied. So trial will be in the larger courtroom, courtroom 3G, which gives me a little bit more assurance that I'd be able to get into the courtroom. So on those days, I won't be streaming the hearings, the trial, but on other days, I do plan on it. I hope you'll join me there. Donna looking forlorn. Wendy's wheels are spinning. I bet. You know she was watching. He does have a soothing voice. This is going to be really good. So we've been here for 2 hours now. The parties finished their hearing before Judge Everett. Let me go quickly over some of the motions that were heard. Oh my gosh, I have a lot of notes, you guys. I've got a lot of notes. I guess she's just waiting for a bailiff to bring her back to the jail. She's not looking so hot though, huh? No smiles like last time. She's got a lot to think about. So the first thing that Judge Everett did was he swore her in and went through the her conflict waiver again, because Judge Everett understands that there could be a huge conflict in her choice of counsel using Daniel Rashbaum, who represented her son Charlie in his case, which Charlie was ultimately convicted, and now he's representing Charlie's mother. So they had, let's see, the motion to dismiss. The judge did not rule on the motion. He reserved ruling. The judge wanted to look at the Katie McBanois trial testimony. Other substantial. Okay. Yeah, the judge wanted to reserve ruling on the motion to dismiss, the general motion to dismiss. It's not going to be dismissed, you guys. And then they went through several other motions as well. You know, they were arguing about the Sun Pass and about the phone record patterns. The judge wanted to reserve ruling because he wanted to go back and look at Katie McBanois' trial testimony to see what she testified to. The state said they did not try to get the information about the Sun Pass before 2013, because in 2013 is when Katie McBanois first kind of connected those dots for them. Let's see. There was the courtroom motion, which I already went over. That was denied. And the judge let it be known that this is his courtroom. He will be given instructions to anybody in the gallery. He said the jury will be instructed to rule on the evidence presented, not on anything that anybody in the gallery does or hints or intimates. The judge said he can't prevent what the defendant is complaining of. He can't prevent that in any courtroom. And how could he? He can't really prevent individuals from doing things before they happen, other than giving, stern instructions. He said that they can move the tables around and they can add an additional table for everybody that needs to be at the defense table. He also mentioned that he wasn't going to allow people in the first 2 or 3 rows behind the defendant, directly behind the defendant, where she's going to be sitting. So people should not be able to, I guess, get a vantage point of any notes that she writes or hear anything between her and her counsel. And finally, he said that other than there being no statutory basis for closing the courtroom to more of the public, the courtroom 3G, which is the larger of the two, it's the most updated and most remodeled courtroom that's in the courthouse. And it's most capable of accommodating all the exhibits and all the technology that both parties will need to use to present to the jury. About the wiretaps, the defense wanted to exclude wiretaps. The court is going to reserve its ruling. It's going to file a written order on that. The jury questionnaire, which was another, kind of a critical motion of the defense, they wanted to have the jury pool answer like really probing and deep questions in writing before jury selection actually begins. The judge said, no, that's not going to be, it's not going to be necessary. The judge is going to give an examination of all the jurors, and he'll ask them about any hardships that they may have in needing to serve on the jury. He's going to get down to the bottom of any, biases that they may have, or if they just seem a little bit too excited in wanting to get on this particular jury. And he, of course, said that both parties can follow up on the questions that he is going to ask the jurors. So there really is no need for them to fill out this long questionnaire before the fact. So that was a big loss, I think, for the defense, because if you were in the live stream that I did yesterday or the day before, I kind of went through why I thought the defense wanted to have people filling out that questionnaire. They got into the motions in limine. There were a lot of them. Let's see. Let me see if I can turn the volume down on what's going on in court. I think Donna's just waiting there. Waiting for a ride back to back home, huh? Surprised the cameras are still there.
That brings us to a conclusion for this morning. Please contact Lynn about the setting of the hearing for next Friday. Everyone have a good day.
Right. Didn't happen.
And turning off the Zoom at this point. Have a good day, everyone.
So counsel was just at the bench speaking with the judge. Just watch Donna for a little bit. Yeah, you're right. You're right, Scariella. She's got that prison pallor now. Charlie was so pale at his trial. No more sun-kissed Florida glow. I wonder if they get time outside at all. You can definitely see that, there's definitely that pallor. How soon after jury selection do we get a trial date? Is there an estimated date yet? We have a trial date. The trial begins with jury selection. Jury selection is starting on Tuesday, September 17th. And testimony will begin as soon as the jury is picked. Opening statements will begin as soon as, they find their jury. But trial is set. We have our trial date. Yeah, I think this long crime stream is over. So, all right. Thank you guys for being here. Thanks so much. All right, the motions in limine. Let's see. Okay, so they kept going through the prongs. I didn't have the actual motions in front of me, so I was keeping notes about, the different things that they wanted to keep out. But the defense didn't want evidence of Donna's wealth to be made known to the jury. So they're arguing that the jury doesn't need to know how wealthy they are. And let's face it, they're wealthy. So the judge granted it in part and denied it in part, basically saying, okay, state, you can let the jury know that they had enough wealth to make the bribe. There was that proposed bribe that Donna suggested to Wendy, giving Dan $1 million to move to South Florida. There was that bribe. So the state will be able to show that, you know, they had the means to support a bribe like that. And that they had the means to pay Katie McVanois. But they would not be able to get into a general presentation of their assets in order to create like a wealth about a bias about their wealth. The statements about Jeff Lacasse, all the TV statements and the hitmen statements and the statements that he brought in, it was cheaper than a hitman. Things that Jeff Lacasse testified that Charlie said, talking about a celebration dinner, the TV statements, cheaper than a hitman. All those statements, the judge is reserving ruling on. So we don't know yet. There were testimony from Wendy Adelson. There were 4 different things that the defense was trying to keep out. Testimony about her book, testimony about the boys' name changes, testimony about blocking the Markel grandparents from seeing their grandchildren, and testimony about the Florida grandparent law that the Markels were proponents of and behind. And let's see, it's granted as to 3 and 4, which I believe are the Markel issues. So they won't be able to introduce evidence about the Florida statute and how the grandparents weren't able to see the boys for many, many years. But the judge is reserving ruling as to the book and the name changes. So we'll have to see if those things get to come in at all. Jailhouse recordings. Now, these are the jailhouse recordings after Charlie's conviction. The judge said he wants to review the calls before making a ruling to see if it's just going to be hearsay or if there's going to be anything relevant to Donna's case. And he said if they do get admitted, which I have a feeling he's probably leaning towards admission, that if they do get admitted, there would be a limiting instruction to the jury about them. The autopsy photos of Dan Markel, that was denied. So the state will be able to present autopsy photos similar to how they presented them in Charlie Adelson's trial. Evidence of Donna's travel to the Vietnam, evidence of, that being her guilt. The judge basically said, that's coming in. The jury will get to decide what her travel and what her travel plans, what they meant. Did they mean she was just going on a vacation? They can come to that conclusion if that's, how they lean, or they can come to the conclusion that she was actually fleeing as a result of guilt that she felt. So that was the end of the defendant's motions in limine. The state had several motions in limine as well. Some about Luis Rivera. We know Luis Rivera was the second, the hitman. He was not the trigger man, but he was in the car when it happened. Member of the Latin Kings. There was a lot of back and forth as to whether that can be introduced to the jury at all. The judge said Rivera's prior bad acts and, his sentences and stuff like that can be admitted, but he is reserving ruling as to whether the actual term Latin Kings can be stated. So we don't know yet if that's actually going to come up. What will be allowed is that Donna knew that there was some association with Lewis and a street gang, a criminal street gang. But as to specifically naming the Latin Kings, the judge wasn't going to go so far as to say that that was allowable. The state had their motion in limine granted to a lot of the other issues that they wanted. They weren't specifying what they were, and I didn't have the motion in front of me, so I don't know exactly what they are. But the defense was agreeing to them. They weren't really fighting any of them. Some of the demonstrative aids, we heard about the Dolce Vita, the Matsuri, and wires and transcripts that were made based on those recordings. The defense didn't have an objection to the transcript from the wires, but they did have objections to the transcripts of the recordings from Dolce Vita and Matsuri restaurant. Now, Dolce Vita is where Charlie and Katie McManawa had this discussion. They're both restaurants. They had the discussion discussing, the bump and everything that was happening subsequent to the bump. And Matsuri, I believe, is the restaurant where Charlie had a discussion with his father, Harvey. So the judge ruled it was granted in part and denied in part. The wiretap transcript is in. The Matsuri transcript is out. Only the transcript. They can hear the recording of that Matsuri discussion, but they can't see the transcript. Just because there were so many things that were inaudible. And the Dolce Vita transcript is granted, but only if there's a witness who can authenticate the accuracy of that transcript. Let's see, what else? Oh, this is where, okay, the next issue was statements being made to gain sympathy for Donna. And these are statements regarding jail conditions, right? And treatment of Donna in jail. And this is where Judge Everett famously is saying, jail sucks. Like, everybody knows jail sucks. Nobody wants to go to jail. Of course not. The judge granted that motion that statements made about Donna's treatment in jail or jail conditions are not going to come in. And they'd only come in if the defense can give some basis of how it's relevant to the case. Finally, the parties agreed to extend their own demonstrative exhibits deadline. That was pushed back to September 4th, which is Tuesday. But I think the parties are agreeing to, get it done when they get it done, and just agree to, keep each other posted on that. They requested to manage themselves a little bit more with the rest of the discovery process. On September 6th, we have another hearing coming up. That hearing is going to be on the defendant's motion in limine to exclude the testimony of Sergeant Christopher Corbett, and the summary exhibit, which includes a whole host of information for the state. Defense has a problem with how it's being presented, and maybe it's problematic, maybe it's not. We'll see on September 6th how that goes. The judge said he does want an update on September 6th as to how discovery is going. So with that was it. We saw Donna. We heard from each of the attorneys, both of her defense counsel. We saw both of the prosecutors. So I think that's about it. Let me just go through the comments really quickly, see if there's anything else here. XYZ, I think she puts on 40 pounds in jail. Oh, is it like college 10, but jail 40? I hope Dan is haunting her right now. I have no pity for this evil woman. I want a life sentence without parole for her. Yeah, she will get what's coming. Had a phone call, missed a lot, darn it. Well, I summarized it a little bit for you. You can always go back and, catch up. Top Cat, hey, hello. That fleeing motion was a big one. Donna looked deflated. Yeah, I mean, she definitely looked deflated in the end. And who knows? I mean, her defense counsel has probably been telling her that, you know, we got this. There's no way. If they've been as braggadocious as they probably were with Charlie Adelson, she probably thought that they were going to go in there and, you know, sweep the room this morning. And that definitely did not happen. That definitely did not happen. Just another Smith. What? Is Emmy typing green cheek? Oh my goodness. I have no idea what that is. Is that the parrot typing just another Smith? Is her name Lucy? If it is, that's super cute. Anyways, you guys, I'm going to give you the rest of your Friday. Thank you for joining me. This was a lot of fun. I appreciate your engagement, your, you know, the laughter, the jokes, so many jokes. And we are going to do this again. Hey, New York Patriot lady, catch the replay, all right? Because I'm on my way out right now. All right, I hope to see you guys again. Okay, bye. Have a good weekend.